Alright, let's talk about the justice system. Specifically, let's talk about the jury. You know, that group of 12 ordinary people pulled from their daily lives, away from their jobs, their families, their cats who are probably plotting world domination, and asked to make a decision that will fundamentally alter someone's existence. It's a system that sounds slightly insane if you think about it for more than 10 seconds. We take a dozen strangers, show them some of the most complex and emotionally draining evidence imaginable, and then say, "All right, you lot, figure it out. And please, try to be back before lunch." It's basically the world's most high-stakes group project, but instead of a passing grade, you're deciding someone's freedom, or, in some cases, their life. The whole point of a jury is to be a check on power. It's supposed to be a panel of your peers, the conscience of the community, who listen to the arguments from both sides, the prosecution, who are trying to prove guilt, and the defense, who are trying to poke holes in that argument. The judge acts as a referee, making sure everyone plays by the rules and doesn't, for example, try to introduce a psychic parrot as a key witness. The jury's job is to sift through all the testimony, the exhibits, and the legal jargon that lawyers love to use and arrive at one simple, earth-shattering conclusion: guilty or not guilty. It's an immense responsibility, one that turns ordinary citizens into the ultimate arbiters of fact. Now, in most regular cases, this is already a Herculean task. Imagine trying to get 12 people to agree on a pizza topping, let alone whether someone committed a crime beyond a reasonable doubt. But when we get to the most serious cases, the ones where the ultimate punishment is on the table, the stakes are ratcheted up to a level that is, frankly, terrifying. We're talking about capital cases, where the jury first has to decide guilt, and then, in a separate phase, decide on the sentence. And in these situations, the pressure to get it right isn't just immense, it's absolute. Because the decision isn't just about prison time anymore, it's about life or death. So, you have these 12 individuals who might have been accountants, teachers, or professional dog walkers just weeks before, sitting in a claustrophobic room. They are entrusted with a decision that society itself is deeply divided on. They are handed the moral and legal weight of choosing between locking someone away forever or sending them to be executed by the state. This isn't just another day at the office. This is a moment where the abstract concept of justice becomes terrifyingly real, and it all rests on the shoulders of 12 people who, just a moment ago, were probably worrying about whether they left the stove on. When it comes to the death penalty, our legal system gets very specific about how the jury needs to make its decision. It's not a simple majority rule situation, like a vote on Survivor. You can't have 7 jurors voting for death and 5 for life, and call it a day. No, for the most final and irreversible punishment the state can inflict, the rule is unanimity. That means every single one of the 12 jurors must agree, all of them, without exception, 100% consensus. It's a principle that underscores the immense gravity of the situation. The system is essentially saying, if we are going to do this, we need to be absolutely, completely, and totally sure. Think about that for a second. The level of agreement required here is almost unheard of in any other part of public life. We can't get 12 people to agree on the best Star Wars movie. And yes, it's obviously The Empire Strikes Back, you animals. We can't get a family of 4 to agree on what to watch on Netflix. Yet, we ask 12 total strangers to come to a single, unified conclusion on whether another human being should live or die. This requirement for unanimity is a safeguard, a legal braking mechanism designed to prevent a rush to judgment and to ensure that any sentence of death is the product of overwhelming certainty from the community's representatives. This rule turns the jury room into a crucible of debate and persuasion. It's not enough for a juror to be personally convinced. They must also be able to articulate their reasoning, listen to others, and engage in what can be an incredibly difficult and emotionally fraught conversation. Each juror holds a powerful veto. A single person, if they hold firm in their conviction that a life sentence is the appropriate punishment, can prevent a death sentence. That individual juror becomes the final barrier, the one dissenting voice that stands between the defendant and the execution chamber. It's an almost unimaginable amount of pressure to place on one person. The logic behind this is clear. If even one juror, after hearing all the evidence and arguments, still has reservations, if they believe the mitigating factors outweigh the aggravating ones, or if they simply hold a moral objection they cannot overcome, then the community, as represented by that jury, does not have the collective moral certainty to impose death. The system demands that a verdict of death be the unambiguous and expressed will of the jury. It's an incredibly high bar to clear, And it's set that high for a reason. Because when the stakes are this high, there is simply no room for doubt or division. So, what happens if the jury tries and just cannot reach that unanimous decision? What if 11 jurors are firmly in the death penalty camp, but one juror number 8, let's call her Brenda, just isn't convinced? Brenda has listened to everything. She's considered all the gruesome details of the crime, but she believes that the defendant's troubled past, or perhaps a lingering doubt, makes a life sentence the only just outcome. The other 11 jurors can argue with her. They can plead, they can re-examine the evidence for hours, even days. But if Brenda holds her ground, the jury is deadlocked. They cannot and will not reach a unanimous verdict for death. In this scenario, you might think the result is a mistrial, a do-over, another lengthy and expensive process. But in the context of a death penalty sentencing phase, something very specific and very important happens. A deadlock is not a failure in the way you might think. By law, if the jury cannot unanimously agree to impose the death penalty, the sentence automatically becomes life in prison without the possibility of parole. Let me repeat that, because it is the crucial point of this entire mess. No unanimity, no death. A single dissenting juror doesn't just cause a stalemate. Their dissent effectively defaults the sentence to life imprisonment. This is a fundamental feature of the capital punishment system. Congress and state legislatures have structured it this way deliberately. The law essentially says that the death penalty is an exceptional punishment that requires an exceptional level of agreement. The default position is life. To get to death, the prosecution has to overcome that default by convincing every single juror. If they fail to convince even one, they haven't met their burden, and the sentence reverts to the default, life. So, a hung jury in a capital sentencing phase isn't a procedural hiccup. It is, in effect, a final resolution. The defendant will not face another jury for sentencing. The outcome is life. This reality transforms the dynamic of the jury room. It means that a juror who is leaning toward a life sentence isn't just arguing for their position. Their individual vote carries the full weight of the law's default outcome. A deadlocked jury is not a non-verdict in practice. While it might not be a formal verdict in the way a unanimous decision is, its consequence is just as final. The inability to agree on death is, by legal design, a decision for life. And this simple fact is at the heart of a massive and massively important legal debate. Now we arrive at the central, slightly bonkers, and intensely debated question. Should the jury be told about this? Should the judge explicitly instruct the 12 people in that room that if they fail to reach a unanimous decision, the defendant will automatically be sentenced to life in prison? On the surface, this seems like a no-brainer. Of course, you should tell them. How can they make a fully informed decision if they don't understand the consequences of all possible outcomes, including their inability to agree? It's like asking someone to choose between 3 doors, but only telling them what's behind 2 of them. It feels fundamentally unfair and honestly a bit silly. However, this is the legal system we're talking about, where nothing is ever simple. There is a fierce disagreement between prosecutors and defense attorneys on this very point. It's a debate that goes to the core of what a jury's role is supposed to be. Is their job to simply vote their conscience on the question of death, or is it to strategically navigate the rules to achieve a desired outcome? This isn't just an academic argument. It has profound, real-world implications for how jurors behave and what decisions they ultimately make when a person's life is hanging in the balance. The core of the conflict is this. Prosecutors often argue that telling the jury about the deadlock rule could encourage a stalemate. They worry that a juror who is leaning toward a life sentence but is in the minority might just dig in their heels and refuse to deliberate, knowing that their single vote is enough to guarantee a life sentence. They argue that this turns the process from a collective deliberation into a simple exercise of one person's veto power. The goal, they say, is for the jury to reach a true, unanimous verdict, whether for life or for death, not for them to strategically engineer a deadlock. On the other side, defense attorneys argue that not telling the jury is misleading and coercive. They contend that a juror in the minority who doesn't know the consequence of a deadlock might feel immense pressure to cave and vote with the majority. Imagine being that one juror holding out for life. You might mistakenly believe that if you don't change your vote, it will result in a mistrial, forcing the victim's family and the defendant through another agonizing trial. Fearing that outcome, you might reluctantly switch your vote to death, not realizing your lone dissent was all that was needed to secure a life sentence. It's a classic catch-22 created by a lack of information. Okay, let's dive into the defense's side of this, the for goodness sake, just tell them camp. Their argument is really rooted in a simple, powerful idea: clarity. Defense attorneys, and, a lot of legal scholars, argue that a jury just can't do its job correctly if it's working under a false understanding of the rules. The entire process of jury deliberation is supposed to be this rational weighing of facts and circumstances. But how can that process actually be rational if the jurors don't know the full consequences of their actions, or, honestly, even more importantly, their inaction? It's kind of like being a contestant on a game show where the host vaguely says, "Just press a button," without ever telling you what any of the buttons actually do. The primary concern here is coercion. So, picture the scene. 11 jurors are convinced the defendant deserves death. One juror disagrees. Without knowing that a deadlock results in a life sentence, that lone juror is in a really vulnerable position. The majority might pressure them, saying things like, "If you don't agree with us, this will all have been for nothing," or "We'll be stuck here forever and have to do this all over again." The holdout juror might wrongly believe that their stubbornness will lead to a brand new trial, putting everyone through the emotional ringer once more. This pressure could easily lead them to abandon their deeply held conviction and vote for death, just to achieve unanimity and avoid what they think is a worse outcome. And look, this isn't just a hypothetical scenario. Studies and post-trial interviews with jurors have shown that this exact confusion actually happens. Jurors have reported feeling immense pressure and have admitted to being confused about what would happen if they didn't agree. They worry about the cost of a new trial, the emotional toll on the victim's family, and honestly, the perception that they have failed in their duty. By withholding this crucial piece of information, that a deadlock is a final resolution for life, the court system risks creating a death sentence that isn't really the product of true, uncoerced unanimity, but rather the result of a misunderstanding and social pressure. Ultimately, the argument for telling the jury is an argument for an honest and fair process. The defense would say that the law, as created by Congress, explicitly states that no unanimity, no death. So, not telling the jury the full truth of that law is basically misleading them into potentially making a decision they would not otherwise make. It's about making sure that a vote for death is a truly affirmative choice made by 12 people who are fully aware of all their options, including, the powerful option of simply disagreeing. It's about making sure that a life or death decision is based on conviction, not on confusion. Now, let's put on our prosecution hat and look at the other side of the coin. The "don't tell them, it complicates things" club. Prosecutors are not, despite what TV dramas might suggest, mustache-twirling villains. Their argument comes from a very different, but equally sincere, view of the jury's role. They believe that the jury's sole function in the sentencing phase is to answer one question, based on the evidence: does this defendant deserve the death penalty? Their job is to deliberate in good faith and try to reach a unanimous answer to that question, yes or no. It is not their job, prosecutors argue, to engage in strategic thinking about procedural outcomes. The main fear is that telling the jury about the deadlock rule could undermine the very nature of deliberation. A juror who is inclined toward a life sentence might hear the instruction and think, "Aha, I don't need to debate or persuade anyone. All I have to do is hold my ground, and I get the outcome I want." This, prosecutors contend, could lead to a juror checking out of the process, refusing to engage with the arguments of their fellow jurors, and essentially holding the deliberation hostage. The goal of the jury room is to be a place of discussion and consensus building, not a place where one person can use a procedural loophole to short-circuit the entire conversation. From the prosecution's perspective, the deadlock provision is a legal backstop, not an official third option for the jury to choose. The law outlines two possible verdicts: a unanimous verdict for life or a unanimous verdict for death. A deadlock is the consequence of failing to reach a verdict, not a verdict in itself. The prosecution emphasizes that a verdict, by its very definition, requires the unanimous consent of all 12 jurors as the conscience of the community. Telling them they can achieve a life sentence by simply not agreeing, they argue, invites them to abdicate their duty to deliberate and reach a true verdict. This viewpoint champions a pure form of deliberation. The idea is that each juror should vote based on their own moral conviction about the appropriate punishment without being influenced by the strategic implications of their vote. They should argue for their position, listen to others, and try their best to reach a consensus. If, after all that effort, they simply cannot agree, then the law steps in and imposes the life sentence. But that should be the result of a genuine, good faith impasse, not a premeditated strategy by a single juror who knows they can get their way by refusing to participate. it's an argument for keeping the jury's focus on the moral question at hand, not the procedural map of how to get there. For the person at the center of all this, the defendant, this debate over jury instructions is anything but academic. It is, quite literally, a matter of life and death. Their fate rests not just on the evidence presented in court, but on the psychological dynamics of a small, sealed room and the instructions that guide the 12 people inside it. The difference between a jury that understands the deadlock rule and one that doesn't could be the difference between spending the rest of their life in prison and being sentenced to execution. The stakes could not possibly be higher. Imagine sitting at the defense table, your life hanging by a thread. You know that the law provides a safeguard. If just one juror holds out for life, your life is spared. Now imagine that the jury is not told about this safeguard. You are forced to hope that a juror who believes you should live has the incredible fortitude to withstand the pressure of the 11 other jurors, all while being ignorant of the true power their single vote holds. It creates a terrifying lottery where your life depends on a juror's mistaken belief about what happens if they don't conform. The fear, from the defendant's perspective, is that a compromise verdict for death could occur. A juror who is exhausted, confused, and under immense pressure from the majority might think, well, I prefer life, but I don't want to cause a mistrial and make everyone go through this again. Maybe I should just give in. This juror isn't voting for death because they are convinced it's the right punishment. They are voting for it to end the deliberation, believing it's the only way to reach a final outcome. Had they known their lone dissent would have resulted in a life sentence, they almost certainly would have held firm. For the defendant, this is a catastrophic failure of the system. This situation puts the defendant in an impossible position. Their fate is being decided by a group of people who may be missing the single most important piece of information relevant to their final decision. The entire legal structure is designed to make the death penalty a difficult and rare outcome, requiring absolute consensus. But by withholding key information, the court could inadvertently be making it easier for a jury to reach a death verdict, not through moral certainty, but through confusion and peer pressure. For the person whose life is on the line, that is a terrifying prospect. This isn't just about the defendant and the lawyers. The jury, remember, is supposed to be the conscience of the community. When a jury imposes a death sentence, it is doing so in the name of the people, in our name. Therefore, we all have a vested interest in making sure that decision is made fairly, deliberately, and with full knowledge of the consequences. If a death sentence is the result of a procedural misunderstanding or a juror's mistaken belief, it undermines the integrity of the entire justice system and the moral authority of the verdict itself. When we, as a society, decide to carry out the ultimate punishment, we rely on the idea that this decision was reached with the utmost care and certainty. The unanimity rule exists to provide that certainty. It ensures that a death sentence is not just a majority opinion, but a reflection of a complete consensus from a cross-section of the community. If that consensus is manufactured through pressure and a lack of information, it calls the entire process into question. It means the community's conscience wasn't truly expressed, it was coerced into a conclusion. Think about the long-term impact. A verdict that is later revealed to have been the product of juror confusion can lead to endless appeals, erode public trust in the courts, and leave a cloud of doubt hanging over the most serious action the state can take. It does a disservice to the victim's family, who are seeking justice and closure, not a verdict tainted by procedural flaws. It does a disservice to the jurors themselves, who may later learn they were pressured into a decision they would not have otherwise made. And it does a disservice to the community, which is asked to stand behind a sentence that was not reached with the clarity the law demands. Ensuring juries are properly informed isn't about helping one side or the other, it's about upholding the principles of the justice system itself. Whether you support or oppose the death penalty, everyone should agree that if it is to be used, it must be the result of a clear, unambiguous, and fully informed decision. A verdict reached in ignorance is not justice, it is a procedural accident. And when the consequence of that accident is death, it is an unacceptable failure of the system that is supposed to represent us all. So, after all this, where do we land? We have a system where 12 ordinary people are given an extraordinary power. In capital cases, they are asked to reach a unanimous decision on death, with the law stating that if they can't, the sentence is automatically life. And yet, we have a furious debate about whether to even tell them that last part. It's a situation that feels less like a finely tuned legal machine and more like a scene from a Kafka novel. where the rules of the game are kept secret from the players. The heart of the matter is simple. Information matters, especially when the stakes are absolute. The arguments against telling the jury that it might encourage a deadlock come from a desire to see jurors deliberate in good faith. That is a laudable goal, but it rests on the risky assumption that withholding information is the best way to achieve it. It prioritizes a theoretical ideal of pure deliberation over the practical reality that confused people can be pressured into making decisions they don't truly believe in. And in a capital case, that's a gamble we simply cannot afford to take. Ultimately, trusting the jury means trusting them with all the information. If we believe 12 citizens are capable of weighing life and death, we should also believe they are capable of understanding the full consequences of their choices without abusing the rules. To do otherwise is to treat them not as responsible decision-makers, but as unpredictable children who can't be trusted with the whole truth. A juror who knows that their single vote for life is decisive is not a rogue agent. They are an empowered participant in the exact system the law created. They are the safeguard the law intended them to be. This isn't just a niche legal topic. It's about the fundamental fairness of our justice system. It's about ensuring that when the state exercises its ultimate power, it does so with a clear mandate from the community, not as the result of a procedural trap. Understanding how a jury room works, especially when a life is on the line, is crucial for all of us. Because the 12 people in that box aren't some special class of citizens. They are us. And their decision, made in our name, should be one based on clarity, conviction, and above all, the complete and honest truth.